My fiance, she said she had the money. Or however it goes, but I got a job already lined up.
Awesome. Oh, yes. All right, everyone, we're not starting up till 1:30, and I know you all are a little bit early. So Michael Goins, what is happening with your case?
Judge, I don't know what happened. You sent me to 19, it transferred me to 16, then 10. At 12:45, I came back to the main room. And Norma said she didn't know what happened to come back at 1:30.
Okay, all right. I'm going to send you to breakout room number 2, okay?
That'll be great, Your Honor. Thank you.
You've been patient, so continue to be patient because the prosecutors are not going to zoom in until 1:30, okay?
I understand, Your Honor. Thank you.
You're welcome. And on Kathy Compton and Robert Gebbia.
Yes, Judge.
All right, so on Miss Cooper, is that going to be a plea? What is happening with Miss Cooper?
Your Honor, we have a plea. We have executed all of our paperwork. I believe Ms. Cooper will need to be sworn in by the Deputy District Clerk. The plea is for a recommendation of deferred adjudication.
All right, so what we're going to do, as soon as they bring your client back on the screen, we'll take care of that. And I'll send you all to breakout room number 1. And the clerk will meet you in, the clerk is already in number 1 with Ms. Cooper. So I'll send you both to number 1 just to make sure that they have everything.
And Judge, I just wanted to let you know, I did message you, but I will be standing in for Mr. Bloomquist on, he had a plea with his client is Daniel Zamarripa. Larry is stuck in Comal County, and I am going to be standing in with his client's permission to do the plea. I believe all the paperwork was executed previously.
Yes, and I do have all that paperwork.
Okay, awesome. I just wanted to make sure you knew. Thank
All right,
you.
thank you. Okay, awesome. Yes. wanted to grab on. Alfonso Cabanas, hi.
Yes, Your Honor. Hi, good afternoon.
All right, are the parties ready on Ms. Cooper? Sherry?
Yes, Judge, I'm ready.
Also ready, Judge.
All right, who is the prosecutor on Cooper?
Joe Ray was working on it.
Joe Ray, Judge, yes.
All right, thank you, Joe Ray.
And
You're welcome.
Judge, just before we begin, I do want to ask the court's permission to make a brief record with Ms. Cooper regarding her immigration admonitions or consequences and our discussions of that.
Sure. And I will let you know when we get to that point, because I usually ask questions concerning immigration issues.
Perfect, thank you.
All right. And I'm assuming we're proceeding on just the one case, is that correct?
That's right, Judge.
All right, the court is calling 2022 CR 0067B, State of Texas versus Sherry Victor Cooper. Could I have parties announced for the record, please, for the state,
Joe Ray Garcia.
for the defense?
Kathy Compton for Ms. Cooper.
All right.
Good afternoon, Your Honor. Robert Gebbia, also present for Ms. Cooper.
All right, and are you Ms. Cooper?
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objection from the state?
No,
No, Your Honor.
Any objection from the defense?
No, Your Honor.
Ms. Cooper, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
yes,
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
yes,
And did you sign it?
yes, I signed it.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
I did as well, Your Honor.
Court will find that the state is in compliance with discovery. Next, Ms. Cooper, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, I understand it.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Cooper, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I understood it and I signed it.
You understand you're charged with fraudulent use or possession of identifying information over 50 items. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes,
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes,
Did you understand by entering this plea bargain agreement, you were giving up those rights?
yes, I do.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes,
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to life in prison and up to a $10,000 fine? Did you understand?
Yes, I understand.
Counsel, has your client been able to provide you with any defenses to this offense?
We have discussed the case, Your Honor, and we've discussed any potential defenses, yes.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Cooper, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
Absolutely not. No.
Are you satisfied with the way you've been represented?
Very much so. Yes, I'm
Are
satisfied.
you a U.S. citizen?
No.
To the defense attorneys, did you advise your client of the consequences of pleading no contest or guilty in the application of federal immigration law?
Yes, Your Honor, just for the record, I am board certified in criminal law. I am also, for the past 20 plus years, and I was an immigration litigator and practitioner. I have discussed with Ms. Cooper that this case, any type of plea, whether it is a deferred, regular probation, prison sentence, whatever it is, that for immigration purposes, this will be considered to be a crime of moral turpitude and or an aggravated felony. And she will absolutely be deportable. She will not be able to apply for naturalization at any point, and she would be excludable from the United States as the law exists. I would ask the court to inquire of my client, knowing that is the result with regard to the immigration consequences if she would like to persist in her plea today.
All right, Ms. Cooper, you've heard your attorney's rendition of what she's informed you with regards to your immigration status and the consequences of entering a plea in this cause number. First, did your attorney instruct you about your immigration status and the consequences of entering a plea today?
Yes.
Right. Did that advice include the possibility of deportation, exclusion from admission to the United States, and the denial of naturalization?
Yes.
And do you understand the immigration consequences of entering a plea in this cause today?
Yes, I do.
Is there anything else, Ms. Compton?
No, Your Honor, thank you.
All right, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, there's a $1,500 fine probated. State recommends deferred adjudication. They will take in consideration 2021 CR 0664, 2022 CR 0068B. There's to be restitution to Todd, TODD, Gloka, GLOWKA, Kaylee, KALI, Heiser, HEISER, Jacqueline, JACLYN, Philly, FILLEY, James Rubin, RUBIN, Velma Della Rosa, DELAROSA. Restitution, if any, also to Linda Long, Sean, SHAWN, Townley, TOWNLEY, Walter D, as in David Smith Jr., and Way Weaverling, WEAVERLING. Did you understand that to be the plea bargain agreement, Ms. Cooper?
Yes, I understand.
Defense, is that the plea bargain agreement?
Yes, Your Honor, it is.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I understand.
Counselor, have there been any such motions?
No, Your Honor.
No, Your Honor, I'm sorry.
Now, outside the plea bargaining agreement, the state is requesting that your deferred adjudication be for a term of 7 years. There be a TAP evaluation, 120 hours of community service restitution, CATs 1 and 2, and no contact with Donald Gilliland, Gilliland. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, I understand that.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea.
State offers State's Exhibit 1 and its attachments.
Any objections?
No objections, Your Honor.
Ms. Cooper, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I reviewed, signed, and understood.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
yes, I understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We're requesting that we do that today, Your Honor, and that we waive the
Anything you wish to say on
PSI.
behalf of your client?
I'm sorry?
Anything you wish to say on behalf of your client?
Well, Your Honor, I would just ask the court to waive the PSI to allow her to complete the TAP from the free world. She is expecting a child. I believe she's due in several days. And that's all we would like to do, is just allow her to have her child somewhere other than Bexar County Jail.
All right, Ms. Cooper, where are you a citizen?
The United Kingdom.
Why were you taking other people's identification?
I pled no contest on that. There's more details to the actual case. I don't know those names. I didn't take those people in
In the
specific.
backpack
Yeah,
was in the hotel room with the person you were with. Did
Yes,
you have
ma'am.
employment?
do I have employment?
No, did you have employment during this time?
No.
So how are you supporting yourself?
I don't have a social security number, so to support myself, I do freelance web and graphic design, and I have my fiance who is supporting me,
Who's your fiance?
Daniel Rono.
Then what were you doing in a hotel with Donald Gilliland?
He had asked me for help multiple times, and eventually I broke, and he asked me to help him check into a room. He had it all set up. He just needed me to use he didn't have an ID. He supposedly got robbed, so I used my ID to check into the room.
When did you meet him?
I met Gilliland years prior to that.
How many children do you have?
I have 5 children. This will be my 6th.
Where are they?
They are with family members.
Why are they not with you?
Because of past CPS cases, I no longer have any CPS cases open, and I finally successfully completed my last one.
Oh, and Judge, before I forget, and I meant to ask this earlier, I would ask with regard to any restitution. I don't anticipate that there will be any, but I would ask the court to order that any restitution that's ordered be ordered joint and severally liable with any co-defendants. her co-defendant at this point is a fugitive. I'm hoping that he eventually will be brought back here, but I definitely do not want my client to be the only one left on the hook for any restitution in the case.
State?
The state doesn't have an objection to joint or severally liable, Your Honor.
Thank you. What drugs were you used or have used in the past, Ms. Cooper?
In the past, my drug of choice was methamphetamine. I've been sober from drugs since August 2019.
Where are your parents?
My parents currently reside in Israel with my sister and brother and their grandkids.
Why are you not there?
Because of my children here, I've been doing the best that I can, learning as I go, to be a support for my children. I've failed many times, but I'm more successful than I have failed. I'm still here for my kids, really. I've been in deportation proceedings before. I have a VAWA application that's pending. That's why I'm still here, mostly for my children.
All right. Court's going to sentence you to 7 years deferred adjudication, $1,500 fine, probated. Take in consideration 2021 CR 0664, 2022 CR 0068B. Restitution, if any, to Todd Gloca, Kylie Heiser, Jacqueline Philly, James Rubin, Velma Della Rosa, Linda Long, Sean Tomley, Walter D. Smith Jr., and Wade Weaverling. 120 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to obtain that, but if you have, or if you do, 40 of those hours will be waived. Cats 1 and 2, there should be no contact with Donald Gilliland. CPS compliance if applicable. GPS, those fees will be waived. The GPS will be removed if necessary for medical appointments or procedures. Regular reporting by Zoom or in person. Proof of employment within 45 days after birth, unless there's complications. If there's some issues with that, Ms. Compton, just let the court know. There's to be no employment as a home health care provider with minors. You're going to do the UA hotline. And restitution will be jointly and severally liable with any co-defendants. Rebecca, is there anything else that she needs?
No, ma'am.
Ms. Cooper, is there anything else you need from the court in order to be successful?
No, ma'am. I believe that's it. Thank you.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Reviewed, understood, and I signed. Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do.
All right, good luck to you, Ms. Cooper. We can go off the record. Ms. Cooper, you need to make a decision on whether or not you're going to be in your children's lives or not. And I'm sorry, Rebecca, could you add parenting classes to that? You're going to complete parenting classes, and once you complete that, the remaining of your community service hours will be waived.
Thank you, and I will.
So, Ms. Cooper, you got to make a decision in your life. Either you're going to be a good influence in your children's lives or you're not. Don't just hang around to cause chaos. You understand? All right, good luck to
Absolutely.
you.
Thank you, ma'am. Thank you.
All right, we're going to keep her here so that probation can speak with her, but it's going to take a moment. Who's here on Isaac Lopez?
I am
Who is I am?
Robert Lopez.
All right, thank you.
May I be excused, Your Honor?
Yes, you may be excused.
Very nice to see you. I hope you have a wonderful day.
All right, thank you. You two have a good one. All right, where is Robert Valdez? Oh, you're in the courtroom. Come on out. I was looking for you on the screen, like, where is he? All right, is there a prosecutor available for a plea on Isaac Lopez?
I'm available, Your Honor. Michelle Hayden.
Thank you. Court is calling 2016 CR 11340, State of Texas versus Isaac Lopez. We have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense.
Robert A. Valdez, Your Honor.
All right, we're proceeding by video due to the pandemic. Any objection from the state?
No, Your Honor.
Any objection from the defense? Go ahead, video, please.
Not from the defendant, Your Honor.
All right. Mr. Lopez, I'm showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled motion to enter adjudication of guilt to revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Isaac Lopez who was placed on deferred adjudication in 2016 CR 11340 for the offense of assault family second offense on September 11, 2017 for a term of 4 years and extended for 1 year? Is that you?
Yes, Your Honor.
State?
Violated condition number 1, on or about the 14th day of February 2022 in Bexar County, Texas. The defendant Isaac Lopez committed the offense of assault in violation of condition number 1.
How do you plead to that, true or not true?
True.
State?
And we're waiving the other 2 allegations.
Any objections to the state's waivers?
No objections, Your Honor.
Mr. Lopez, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court is finding violation of condition number 1 true. Is there an agreement?
Yes, Your Honor. The agreement is for revocation and to recommend a sentence of 3 years and take into consideration grand jury numbers 766-437, 771-354, and 771-355, and a no contact order with Nancy Mendez.
All right, is that the agreement?
That is my understanding, Your Honor.
Mr. Lopez, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will follow your agreement. The court will grant the motion, find you guilty, sentence you to 3 years in the prison, give you credit for any time served. Take in consideration grand jury number 766-437, 771-354, 771-355. There's to be no contact with Nancy Mendez. There's to be no contact with Argelia, Argelia Rivas. There's an affirmative finding of family violence. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction and because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Lopez. It appears to the court that you should not be in any relationships because you're not adult enough to be involved in one. If you continue on the path that you're on, you're going to end up having a habitual status tagged to your name, which means your minimum will be 25 years or life. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Lopez. You're excused. Thank you.
Thank you, Your Honor.
And then the other one is, who are the parties on Danielle Zamarripa?
Judge, that is the plea that I'm standing in for Mr. Bloomquist on, and I believe that Mr. Zamarripa is here. He's on bond, and he's given his permission for me to stand in for Larry.
All right, who's the prosecutor?
That's Michael Villarreal.
Judge, I can stand in for Michael.
Oh, he's approached, or do you want,
Oh, he's in there? Okay.
you want to continue to confirm?
If I can, Judge.
Yes.
Okay.
Okay, thank you. All right, thank you. Court is calling 2021 CR 10988, State of Texas versus Daniel Rios Zamarripa. Could I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Kathy Compton standing in for Larry Bloomquist, Your Honor.
And are you Daniel Zamarripa?
Yes, ma'am.
Do you have any objections to Ms. Compton standing in for your attorney?
No, Your Honor.
All right, we're proceeding by video due to the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
No, Your Honor.
Mr. Zamarripa, I'm showing you what's entitled defendant's consent to appear by video conference. Did you review that with your attorney? Did you understand it? Did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it? Did you electronically sign it?
Yes, Your Honor.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
According to Mr. Bloomquist, yes, Your Honor.
Court will find that the state is in compliance with discovery. Mrs. Zamarripa, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, I do.
State, it appears that you're proceeding on indecency with the child contact. Is that correct?
I believe that is correct, Your Honor.
Any objections?
No, Your Honor.
Mrs. Zamarripa, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the offense of indecency with the child contact? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
I've spoken with Mr. Bloomquist and I understand that he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
According to Mr. Bloomquist, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
According to Mr. Bloomquist, yes, he is.
Mrs. Zamarripa, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you into this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of indecency with a child contact. Punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine, and the state is going to remain silent on your application. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
And Mr. Zamarripa, do you understand with a conviction or a deferred adjudication for this offense, you are required to register for the rest of your life? Do you understand that?
Yes, Your Honor.
And knowing that, do you still wish to go forward with the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, are there any such motions?
I believe not, Your Honor.
Then Mr. Zamarripa, to the offense of indecency with a child contact, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
State offers State's Exhibit 1 and its attachments into evidence.
Any objections?
No objection.
Mrs. Zamarripa, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Do you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty as you apply for deferred adjudication. Can I have a date for sentencing? Yes, he's on bond. All right, we're going to come back on June 30th. And at that time, the court will make a decision on your application. You will need to appear in the court on June 30th at 9 a.m.
Yes, Your Honor.
All right, and at that time, the court will make its decision. We will send you to a breakout room and probation will tell you what you need to do.
At this time?
Yes, you're going to go to a breakout room to speak with probation.
Okay, thank you.
Judge, can I be excused?
Just hang on one moment, Miss Compton.
Sure, sure.
Will they not be able to contact her? All right, Jan, we'll see about Miss Compton. Miss Compton, I'm going to send you to breakout room number 1. I'm sorry, someone's in one. Let me send you to number 4. And Norma will speak with you in there.
Okay, that sounds good. Thank you, Judge.
You're welcome. And probation, you can go to breakout room number 1 now. And Mr. Daniel Zamarripa, I'm going to send you to breakout room number 1.
And I'll let Larry know of the new date. You said June 30th, Judge?
It's June 30th at 9.
Yes, ma'am.
Can I have the parties on this trial approach? And Brenda, we can
need to run to the back.
No problem. All right, Nathaniel Navy.
Yes, Judge. I conferred with the state. This was our very first setting, Judge. If I could get a reset, I'll probably be requesting the breath discovery, Judge.
All right, who's your client?
Carlos Gonzalez.
All right, Ms. Ferguson.
Yes, ma'am.
All right, Kathy Compton is waiting for you in breakout room number 4. But could I have a 30-day reset on Mr. Carlos Gonzalez, please?
Yes, ma'am.
All right, we're going to come back on May 25th.
Thank you, Judge. May he be excused?
Yes.
Thank you. May 25th.
Judge, can you make me a co-host?
Yes.
Thank you.
All right, Luis Martinez.
Judge, I'm hearing.
Luis, I can't hear you. There's something wrong with your audio. While you're working that out.
Is that any better?
Yes, that's better.
Okay, I'm sorry. I just did mute and unmute. I don't know what the problem was.
Who's your client?
Gilberto Guajardo, Judge, he's in custody. And I apologize for being late, but it was a crazy morning.
No problem. Okay, does he have several different middle names?
I don't know, Judge,
Yes,
we
I
have several
have
cases.
Gilberto Guajardo. I have Gilberto Chavarria Guajardo and Gilberto Chavarria.
It looks like that. Yeah, they've got him under a Gilberto E. Guajardo, C. Guajardo, and then just Gilberto Guajardo.
All right, we'll come back on May 25th.
Judge, we've got an agreement on that. I don't know if we want to hold on or if you just want us to come back.
No, we can do the plea if you have an agreement. We can do it during break.
Okay.
All right, thank you. What I'll
You're welcome,
ask though, because we're starting up a jury trial, I'm going to send you to a breakout room with your client. Please do not leave the breakout room until I, remove you from the breakout room.
Okay, he's still in the room. I can go back to that room, Judge. I was just putting the agreement in the chat box.
All right, thank you.
Thank you, Judge.
All right. Michael Goins.
I was just wondering if anybody from CTD had showed up, Your Honor.
All right, and your client is Luvano?
Yes, Your Honor, that is correct.
All right, I'll send you to a breakout room. Please do not leave that breakout room until I have you removed from that breakout room, okay? Don't come back to the main
Your
room.
Honor, the only problem I have is I've got a BA appointment at 3 o'clock.
Okay, well, we'll see you tomorrow then.
That'll be fine, Your Honor. What time?
9 o'clock.
I'll be on at 9 o'clock, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, Fernando Ramos?
Ma'am, still here.
Yes. Yes, what is happening to your case?
I had waited for Michael to show up. He made a brief appearance, and I guess he was too busy. Didn't never came back.
All right, we'll see you back tomorrow then. He'll be available then.
Will we get a new link as well, Judge?
Yes, you will.
At 9 o'clock?
Yes, 9 a.m.
Same for Judge.
You're welcome.
May I be put in a room with my client and then be excused from there?
All right, just 1 second.
Sure.
These can go back. All right, I'll review it. All right, thank you. All right, Mr. Sanchez. I'm sorry, Mr. Ramos, your client is not on the Zoom, so we'll have to just bring you back tomorrow, okay?
He's in custody, Judge. He's right there. Laura.
Ah. I'll send you to number 3.
Thank you, Judge. And may I choose from there?
Yes.
Thanks, Judge. See you tomorrow.
All right, Kenneth Baker.
Yes, Judge. Hi, good afternoon. I've got Miss Williams, Sharon A. Is she logged in?
She's not here. We'll recall you for tomorrow, Mr. Baker.
Okay, good, because I'm in communication and I'm not sure what's the problem. She's kind of, so I'll make sure that she's here.
All right, we'll see you tomorrow. Thank you.
Thank you, Ron.
Bye. Ms. Gomez, I'm going to send you to a breakout room. I'm going to send you to breakout room number 5.
Okay.
Mr. Gonzalez, Carlos Gonzalez, you'll need to be back tomorrow.
Yes, ma'am.
All right, we can take the inmates back. All right, who are we doing paperwork on in the box?
I don't want to, Joshua Hamilton. I'm working on it.
Okay, awesome. So if we can just leave him in the back, I think I'm sure Judge Saldana's court is available if we need that, but if we could put him in the back, they're doing paperwork for him though.
Okay, we could just leave him here.
Okay, all right, thank you.
Can we approach?
Yes.
Mr. Engelke and I have Mr. Orozco who's being taken back.
Yes.
I spoke with Mr. Villarreal. We would be requesting a 2-week reset. They need to confer with the complaining witness based on some information I provided.
All right, if you will go to the back and speak with Miss Ferguson and ask her to tell her I said that you're to have a 2-week reset.
Yes, Your Honor.
All right, thank you. Thank you for your
I'm
patience.
joining her in that motion because the state has indicated to me that they don't want to do anything
Okay.
on my case until her case is taken.
All right, thank you. So we'll see you back in 2 weeks. So just go to the back and get the reset form from Miss Ferguson.
Thank you.
Miss Ferguson, there are 2 people coming to the back for a 2-week reset. Yes.
Hi, Judge. I have 2 announcements from clients that were on the trial docket this morning. Adrian Garcia, going back.
Yes.
And then Mr. Williams, who's right outside.
Yes.
So do we get resets from Ms. Ferguson?
Yes.
Okay.
So you go to the back and let her know it's being reset.
Yes, Your Honor.
All right, and so what we'll do is we'll bring that 1 juror out first.
Okay.
And y'all can question her if you choose to.
Okay. Judge, if you can give me a second, let me get my partner here and we'll be good to go.
Oh, sure, take your time. Yes.
Brian Groomer for the state of Texas.
And for the defense?
Eddie Brobenick from Mr. Contreras.
All right, the court was made aware that there is an issue with one of the jurors. Miss, what is your name?
Sylvia Flores.
All right, so the juror called in, and as both parties know, the jurors are given the courtroom number if they're going to be late or if there's some emergency to call in. But this juror called in with other issues. So would anyone like to question the juror with regards to the
Judge, at this time, the state would make a challenge for cause under 3516 regarding Ms. Zavala. I think she's indicated that a bias or prejudice she has against the state in terms of her religious, she would not be able to render a fair verdict. Judge, I believe at this point, we would ask for you to excuse her and to appoint the one of the alternates, Judge. I believe at this point, the jury hasn't been sworn, and therefore Article 35 still applies. I believe that there's an affirmative duty under there for any reason unlisted under 3516 for a challenge for cause to be granted. And in this particular case, I think that she's indicated by her bias and prejudice that she would not be able to render a fair verdict. Judge, we would ask for her to be struck for cause, and we would ask for the alternate to be brought in based on the information that we have received prior to the swearing in of the jury.
Mr. Broadway?
Sorry, I have a bad habit of interrupting, so I try to make absolutely clear that I'm not doing so. So Judge, Mr. Groomer pointed out something that I do believe is very important, which is that we've already made our peremptory strikes, but we've not seated the jury. Clearly, this jury is favorable to the defense. I thought so when I saw her there. Mr. Groomer and Mr. Sanders chose not to use one of the peremptory strikes. It's a little different. The juror has to say, I have a religious belief that prevents me from doing this, but she can't really say that. All she can say is, I read a portion of the Bible that I'm currently interpreting as saying I can't do that. So before we end up giving the state an 11th peremptory strike, which clearly I think we're doing here, I think we need to either give her the chance to talk to the pastor or hear more. I would also argue to the court, I think bluntly, she probably does not want to be on this jury. And I think that if you denied this, there would probably be a third or fourth excuse also, which would probably not be legally okay. And I have some sympathy for not wanting to serve on the jury. However, when it comes down to it, that is part of our duties. We have to pay taxes, serve on a jury, and if we have a war and there's a draft, do that. That's it. So what she's saying is everyone else has to serve on the jury, but because she doesn't want to, she can come up with excuse after excuse. Didn't want to say this in front of her face because I didn't want to make her a hostile jury. But my argument is it would give the state an 11th peremptory strike. And then second of all, that she has not complied with the legal standard for saying that she has a religious belief that does not allow her to sit in judgment.
Do you want to address his issue with regards to the standard as far as her not stating that her religious belief will preclude her from sitting in judgment or passing judgment?
Judge, I believe she did. I believe she strictly said, or she said whenever we were questioning her, that based on her feelings regarding her religion, who was she to be able to say these things? And I asked her, because at first she said, I don't think I would. I went back and said, look, we need to know for sure. Would you be able to, yes or no? And she said she wouldn't be able to sit in judgment and render a verdict in a case like this based on her religious beliefs, Judge. I asked her specifically, we all bring things to the table. It's not what we feel like or whatever, but would you be able to do that? I went through all that questioning and she still said she would not be able to set those feelings aside and be able to be a fair and impartial juror in this case.
May I respond?
Yes.
All right, and I promise there won't be a back and forth. This is my last. So she's a classic equivocating juror. When I said, did you read the whole passage? She said no. When I said, read the whole passage, he's not talking about the criminal law. She said, oh, I didn't know that. I understand that using the limited interpretation of reading part of a passage, it's like reading part of a law and saying you understand it, not reading the whole thing. She thought she couldn't sit in judgment. However, when explained that it had nothing to do with the criminal law, she was like, oh, I didn't know that. So all of Mr. Groomer's questions were predicated on the fact that that portion of Matthew, which I'm intimately familiar with, applied to the criminal law. And when told it did not, she then changed her position. That's it.
All right, thank you. State's motion will be denied. Let's bring the jury in.
Judge, I'm sorry, before we bring the jury in, and sorry for the last minute notice, I filed a motion and let me just now may I approach the board?
Yes.
Also, oh yeah. And I just gave it to Eddie, so I'm sure I'm just
Yeah. Reading it is generally good.
It's something that came up in Bordar yesterday as far as actual fear, and whether the victims were placed in fear.
Okay.
I'm asking that the court, I guess, order that defense approach before getting to that subject. I believe that if you were allowed to get into it without approaching, it would unfairly prejudice the state. It would be misleading to the jury because the law, as I provided to the court and to defense, is that there is no requirement that the victim perceives a threat. The case that I cited and provided to the court and defense is in Ray AJRT. And the court says it specifically.
All right. All right, defense, just approach if you're going to question about that.
May I respond?
Yes.
So Judge, I have two real issues about it. The first one is that I am now standing about to begin the jury trial, and I will tell you, I prepared all my questions based on asking areas on this issue. So when you say approach, we just got to deal with it now. My second thing, I mean, or we can reset this cause and try it again. Agree, I don't want to do that either.
Well, so here's the thing, that this motion in limine, of course, people can file motion in limine whenever they want to file them. But, well, no, here, I've done the research, but here's the thing about that. I can't rule on a motion in limine as far as saying, oh, yes, you're allowed to question about this or that, because I don't know anything about this case. I don't know what the witnesses are going to testify to. Just approach.
Well, so we do have a due process right to notice. And I understand that the supposedly ambushing person literally on the 11th hour and 59th minute may satisfy the statute, but as you remember the due process clause, it's not only the laws have to be on the books, but they also have to be fair. So I have prepared our entire case on the issue of questioning them, were they afraid? Because that's an element of the crime. So if I am now not allowed to, an opening statement, talk about that issue.
Opening statements.
Shouldn't be argument, right?
Their opening statement is not evidence. What I can tell you is, with regards to the motion in limine, just ask to approach, because I don't know anything about this case.
So I'm trying to respect the court on the other side. Here it says is specifically any argument. So opening statement, of course, is not evidence, nor is it argument. So I feel free, because they have not raised the issue, to say anything in opening statement that is necessary.
Yes.
I also, and I'm not
You
trying
can
to
make
parse
your,
things.
you can make your opening statement. I've read the motion in limine, and the motion in limine is for argument. It's for witnesses when they testify. That is what this motion says. You can do your opening statement, because opening statements are opening statements. They're not evidence. It's just what you expect the evidence to show. And when witnesses testify, if you're going to question them on this matter, just ask to approach.
All right, well, so my other thing is that here, once again, it says any argument that the victims, I'm going to ask them questions that relate to whether they were afraid. I mean, that's part and parcel of what's going on.
Just ask to approach.
Okay, well, so the state has to ask questions about that too. May I have a opposing motion to limine, since I didn't say that they have to approach before asking any fear questions to their as well?
Yes, you all can. Here's the thing, people, just ask to approach. Just ask to approach.
Yeah.
One more final thing. On count 4, we're waiving the entirety of count 4.
Okay. Any objections?
May I have just a moment to explain it to my client?
Yes.
So we're going to, they're asking to state charges or other things. They're asking to charge you. I have to tell you, I can't. So I'm just explaining to you before I agree. Judge, my apologies, we have no objection.
All right, then count 4 is waived without objection. Do you know if they finished the paperwork in the back?
That almost finished, I believe.
Oh, sure. How
many? 5 minutes.
All right, so then what we'll do is when I do that, we'll just let the jurors know that anyone who needs a break they can take a quick break and then we'll start with jury selection.
You can break right now.
Yes, they can have a break.
Judge, do you have a problem if I read our own indictment, or do you want me to read the court's indictment?
No, you can reach your assignment. Yes. All right, so what is your client's name, please?
Joshua Hamilton.
All right, he's only pleading on one case.
No, Judge, we've got a plea on 2 cases.
One's a waiver, Judge. One's a judge.
All right, thank you. Luis Perez, who do you have? Luis Martinez, I'm sorry, who do you have?
Judge, Gilbert Guajardo. And he's pleading in 2 cases, Judge.
Okay. All right, the court is calling 2022 CR 3892W and 2021 CR 9281 State of Texas versus Joshua Hamilton. And I have parties announced for the record for the state,
Michael Villarreal for the state.
for the defense.
Monica Corrala for defense.
And are you Mr. Hamilton?
Yes.
Counsel, have you received all the discovery in each of these cases and did you review them with your client?
Yes, I did, Judge.
In each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Hamilton, in cause number 2022 CR 3892W, I'm showing you what's entitled waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review those documents with your attorney? Did you understand them and did you sign them?
Yes, Your Honor.
Did you understand you have a right to have a grand jury hear the evidence in this case, make a decision on whether or not to indict, and that your attorney has certain rights, namely 2 days before the presentation of the information and 10 days from the presentation of the information to prepare for trial? Did you understand?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In that cause number, I'm showing you what's entitled information. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive reading of the information?
I do, Judge.
State, are you proceeding on the information as presented?
The information is presented, yes, Judge.
And in cause number 2021 CR 9281, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state's waiving and evading the repeat offender allegation.
Any objection?
No objection.
In each of the cause numbers, I'm going to show you what's entitled court admonishments, defendants, waivers, and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
In each of the cause numbers, you charged with felon in possession of a firearm. Those are 3rd-degree felonies. The range of punishments anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea bargain agreement in each one of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses in each of these cause numbers?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hamilton, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain pages. Did you review those pages with your attorney? Did you understand them?
Yes, Your Honor.
Did you understand in each of the cause numbers, the state is requesting that your punishment be assessed at 7 years prison? Each of the cases were run concurrent. The state is taking consideration night mag number 654-758, 654-766, and grand jury number 763071. Did you understand that to be the plea bargain agreement?
Yes, sir.
Defense, is that the plea bargain agreement?
Yes, Judge, it is.
State, is that the plea bargain agreement?
Yes, Your Honor.
And state, is that a 5 or a 6? Am I reading that correctly?
On the cause number, Judge?
It's a 756, I think is the last three.
Okay,
I'm sorry, Judge. My
Right.
penmanship wasn't great.
no problem. So that is night mag number 654756.
Correct.
Mr. I'm sorry, state, did you understand that to be the plea bargain agreement?
Yes, Your Honor.
And defense, is that the plea bargain agreement?
Yes, Judge.
And Mr. Hamilton, again, did you understand that was the plea bargain agreement in each of the cause numbers?
Yes, Your Honor.
In each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it?
Yes,
And
Your
did
Honor.
you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Then each of the cause numbers, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea in each of these cause numbers.
Yes, Your Honor. In each case, state would offer state's exhibit number 1 and its attachments.
Any objections?
No objection.
Mr. Hamilton, in each of these cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments and review the same.
Your Honor, if I may briefly,
Yes,
if I can take my client on a brief voir dire.
yes, you may do.
Mr. Hamilton, you understand that the issues before the court right now are going to be a plea bargain agreement on several cases. Is that correct?
Yes.
You retain our office to represent you on just one of them. Is that fair?
Yes.
You have a court-appointed attorney that represents you on the others.
Yes.
Now, it's your understanding after a jail visit with your court-appointed attorney by the name of Matthew Brown, and after a phone conversation with, that I had with him, that you're okay with me standing in and substituting on these particular new cases that you picked up in March.
Yes.
All right, and it's your understanding that your attorney believes it's in your best interest to accept the plea bargain that we agreed to today.
Yes.
I have an email that he did send me today that does testify to that fact, but I just wanted it on the record that I don't actually represent you in those other charges. However, I am subbing in today after receiving the evidence last night on them and discussing it with you and with your court-appointed attorney.
Yes.
Okay, that's all. Judge.
All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
And each of the cause numbers, the court will sentence you to 7 years in the prison, give you credit for any time served. Each cause numbers will run concurrent. So 2020 CR 3892W will run concurrent with 2021 CR 9281. In each of the cause numbers, the court will take in consideration night mag number 654758. And night mag number 654756, grand jury number 763071. Is there anything else from either side with regards to sentencing?
I think for the mistake.
Nothing from defense.
In each of the cause numbers, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
All right, because there's a plea bargain agreement in each of these cause numbers, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because these are felony convictions, which you obviously do, you are not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak with your attorney. Do you understand?
Yes.
All right, if there's nothing else, Mr. Hamilton, good luck to you, Mr. Hamilton. You were indicted as a repeater. The next time you come back, you could be indicted as a habitual offender, which means your minimum may be 25 years. You understand?
Yes, Your Honor.
All right, Ms. Hamilton, Mr. Hamilton, good luck to you. And I don't know how they removed that piercing in your,
It's a shirt, man.
was it painful? Did they put you
No,
under
I've
to
had
do
it
it?
since 2010.
How do you clean it? Or you just don't?
Well, at first it's a month. You gotta put peroxide in it after you get it, and then it just heals.
Oh, okay. All right, have a great rest of your day
All right,
and
you
do
too.
better, okay?
Okay, I will.
All right, thank you.
Your Honor, there's certain things you cannot unhear.
You
remember those.
You was where you got it, Judge? It's-
No, I'm not. You know what? My mom would have words for you if I were to do that. And I don't like pain, so it won't happen.
She doesn't, kid. I would never suggest you do that.
Mr. Martinez, I'm gonna send you to a breakout room. What is happening?
Ma'am?
All right, let's bring the jurors in.
Yes, I'm waiting for.
Yes, okay.
He'll be like.
All right, thank you.
Judge, I'm only saying this because you listened to 911 tapes.
Yes.
Did you want to do that later on as far as my objections, or did you want to do that?
Oh, I mean, we can do it once they present it and you can make your objections.
Thank you, Judge. May I be excused?
Thank you. Thank you so much for your patience. I had no idea we were going to be at the same event.
Fine. Thanks.
Sure, bye-bye.
Judge, have you granted the state's motion in limine to keep Mr. Bravenette from talking?
Well, they don't have to keep me from leaving St. Louis. That's already a self-inflicted one.
All right, so Ms. Martinez, we're going to start a jury trial right now. And my understanding, you have a plea. So as soon as that's done and we take a break, we'll take that up. Oh, you're muted.
Oh, I'll sit in the breakout room. Thank you, Judge.
All right, thank you. And if it gets too late and you need to leave, then we can just do it tomorrow morning.
Whatever works.
All right.
I'm getting out of town, so Judge, I'd like to get today.
All right, thank you.
Thank you.
Judge, I just approved the paperwork.
All right, well, we're going to bring the jury in. Brenda, there's a lot of paperwork signing right now.
Ready, Judge?
Yes, we're ready.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, I know we said we would start at 2 and we're starting, of course, much later than 2. But there were other matters that were beyond our control that we had to take up. And the matters that I had to take up had nothing to do with the state or the defense. So I want to let you know that. All right, if you all could raise your right hand for me, please. Do you and each of you solemnly swear or affirm in the case of State of Texas versus Mr. Contreras, you will a true verdict render according to the law and the evidence, so help you God? Yes. All right, you can lower your hand. State.
Thank you, Judge. True bill of indictment. In the name and by the authority of the state of Texas, the grand jury of Bexar County, state of Texas, duly organized and paneled and sworn at such at the July term AD 2019 of the Judicial District Court of said county in said court at said term, do present in and to said court that in the county and state aforesaid and anterior to the presentment of this indictment. Count 1, on or about the 11th day of June 2019, Marco Contreras, hereinafter referred to as defendant, while in the course of committing theft of property and with intent to obtain and maintain control of said property, did intentionally and knowingly threaten and place Andrew Trevino in fear of imminent bodily injury and death, and the defendant did use and exhibit a deadly weapon, to wit, a knife or bolt cutters, that in the manner of its use was capable of causing death and serious bodily injury. Count 2, on or about the 11th day of June of 2019, Marco Contreras, hereinafter referred to as defendant, while in the course of committing theft of property and with intent to obtain and maintain control of said property, did intentionally and knowingly threaten and place Arnulfo Canedo in fear of imminent bodily injury and death, and the defendant did use and exhibit a deadly weapon, to wit, a knife or box cutter, that in its manner of use and intended use was capable of causing death and serious bodily injury. On or about, count 3, on or about the 11th day of June 2019, Marco Contreras, hereinafter referred to as defendant, while in the course of committing theft of property and with intent to obtain and maintain control of said property, did intentionally and knowingly place Quest Young in fear of imminent bodily injury and death, and the defendant did use and exhibit a deadly weapon, to wit, a knife, that in the manner of its use and intended use was capable of causing death and serious bodily injury. Against the peace and dignity of the state, undersigned foreman of the grand jury.
All right, to count 1, how do you plead? Guilty, not guilty, or no contest?
Not guilty.
Count 2, how do you plead? Guilty, not guilty, or no contest?
Not guilty.
Count 3, how do you plead? Guilty, not guilty, or no contest?
Not guilty.
All right, thank you. State, do you have opening statements?
Yes, Judge.
All right, you may proceed.
Thank you. So, life is all about choices and consequences. We're here today because of choices that the defendant made on June 11th, 2019. Throughout the course of this trial, you're going to hear about the choices that he made. You're going to hear about what happened. As I told you during opening, we're here for an aggravated robbery case. On June 11th of 2019, you're going to hear testimony from a few different witnesses, specifically Quest Young and Andrew Trevino. They work at the Wash Inn over on 2230 Southeast Military Drive. It's close to Lake City base. You're going to hear from Quest and Andrew that they were there working when one of the employees came in. That they had another coworker there who worked there named Arnold or Arnolfo. He would ride his bike to work. That while they were working, one of the other employees came in and said, "Hey, someone out there trying to steal Arnold's bike." So Andrew and Arnold, they go outside to see what's going on. It's the defendant. He has a pair of bolt cutters and he's trying to cut the chain for Arnold's bike. Andrew confronts him. He's like, "What are you doing?" He's like, "I'm stealing his bike." The defendant's like, "I'm stealing the bike." Andrew's like, "You're not going to take the bike." The defendant's like, "Yeah, I am." They go back and forth, back and forth. As they approach him, you're going to hear testimony that the defendant reaches behind his back as if he has something. So both Arnold and Andrew, they take a step back. They're not sure what's going on. Keep going on, keeps cutting at the bike. Finally, when he gets it and snaps off the chain, that's when Andrew jumps in, he grabs the bike and pulls it away. At this point, you're going to hear that it was still Andrew and Arnold outside, but that the defendant actually pulled out a knife. He pulled out a knife and threatened Andrew and Arnold. A few seconds later, a couple of other guys come out. Quest is one of those guys. The defendant is still outside. He pulls out the knife again. He threatens him again. You're going to see surveillance video where the defendant comes after him with a knife. You're going to hear that there was sort of a standoff until eventually, I guess, the defendant, he felt that he was outnumbered and he walks away. You're going to hear that he ran out, that Andrew followed him. He sees the defendant hop on another bike, a red bike, and take off. That they call 911, they give a description of what he's wearing, where he's headed, what kind of bike he's on, and that there's officers to find him. You're going to hear from the officers who make the scene, the officers that find him, that he matched the description. You're going to hear, unfortunately, that they didn't find a weapon. They didn't find the knife, they didn't find the bolt cutters. But through the evidence, you're gonna hear why. You're gonna hear that he was headed in one direction, he was found in a completely different area. The area is full of trees, brush. There's no way that they would find the knife or the bolt cutter. But based on the evidence and the testimony, you're gonna hear for sure that he had bolt cutters and a knife, and that he threatened Andrew, Arnold, and West with that knife. So at the end of the case, after proven that on June 11, 2019, that the defendant committed aggravated robbery, we're gonna ask that the find guilty.
Right, defense.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. This case is really about holding Mr. Contreras responsible for what he did and not acting out of fear, anger, or something else to punish him for something he didn't do. What we believe is that the evidence will show that it's very likely that people are going to testify that Mr. Contreras was out at the restaurant that day. I think it's also very likely that the testimony is going to show that Mr. Contreras, for whatever reason, thought it was a very good idea to use bolt cutters to try to cut the bolt on the bike. Although he did not end up with the bike, I think that the evidence is going to show you that there's a very good chance that Mr. Contreras is guilty of either a theft or an intent. Of course, that's not what Mr. Contreras is charged with today. As you remember from Vordaer, an aggravated robbery requires theft, special kind of assault, and then a weapon. And it can't just be a weapon that's there, it has to be a weapon used in a particular way. So we've dealt with the theft. It was very easy, much as in Vordaer. I'd like to talk about the evidence that we believe will be presented with regards to the assault element of it. So what you'll notice in the testimony that you get, I believe, is not that Mr. Contreras ever took the knife and moved forward to something. We don't believe the evidence will ever say, I'm going to use this, I'm going to cut your throat. What we believe the evidence is going to show is when he was initially confronted, in fact, the knife didn't come out at all. It was only after Mr. Contreras was surrounded by 4 or 5 people, and he evidently must have felt threatened, that then the knife came out. So the difference that the evidence is going to show you is using a knife in an assaultive manner and a defensive manner. It may seem a small thing, but after all, we're talking about evidence showing the difference between a theft and an aggravated robbery. Once again, on an aggravated robbery, you have to use the weapon in a way that's going to cause, in its intended use and manner, put someone at fear of bodily injury or death. We believe the evidence is going to show that the knife was not used in anything. It was simply pulled out. So this case and the evidence you're going to receive, we believe is going to show you that Mr. Contreras was in fact there, that he did in fact, for whatever stupid reason on God's green earth, decided it was a good idea to use bolt cutters and attempt to steal a bike while riding a bike. However, we believe the evidence is not going to show the other 2 elements of robbery and aggravated robbery. Thank you.
Right, state, call your first witness.
Your Honor, the state calls Alec Cosio.
If you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you state your name for the record, please.
Alec Cosio.
State.
Thank you, Judge. Good afternoon, Officer Cosio. Are you currently employed?
By the San Antonio Police Department as a patrol officer.
How long have you been employed with San Antonio Police?
5 years.
As an officer with San Antonio Police, where are you stationed?
Central View shift.
Have you always been central?
No, I've also worked on South and West.
What area is central?
Central covers downtown.
Okay, and then what about South?
South covers everything under Highway 90.
Back in 2019, where were you stationed?
South View shift.
As an officer in South View shift, I guess what are your duties?
Patrol.
And are you a certified police officer?
Yes.
Did you have to go through training to become a certified police officer?
Yes,
And are you licensed by the state?
yes,
When you're on patrol, is it your duty to respond to calls for service?
yes,
Do you recall if you were dispatched out on June 11th of 2019?
yes.
Do you remember the location where you were dispatched to?
I don't remember the address off the top of my head.
Would you have made a report if you were dispatched out to a location?
Yes.
Your Honor, my first witness.
Yes.
Officer, firstly, I'm going to show you what's been marked as State's Exhibit A. Is that a copy of your report?
Yes.
Okay. You can use it to refresh your memory. You just can't read directly from it. So take a moment to look at your report. And if you could tell the jury, where were you dispatched out to?
2230 Southeast Military Drive.
And is that within Bear County?
Yes,
Okay. Do you remember what type of location that was?
it was a Chinese restaurant.
Do you remember the name of the restaurant?
Walk-in,
And what were you dispatched out there for?
robbery in progress.
Did you have any other additional information before you got there? If you remember?
Not that I can remember.
Okay. Once you made that scene, do you recall who was there?
Once I made the scene, I spoke to one of the witnesses. And the victim.
Was the suspect still there?
No,
After speaking to the witness and the victim, were you able to get information as to who the suspect was or identifying information?
yes, I was.
Once you received that information, what did you do with it?
I put it out over the radio so that other responding officers were aware of the situation.
Okay. Do you remember what description was that you put out over the radio?
My description said that he was a black male with a short afro, and he had a bicycle with him. And I recall saying that he had some white Nikes on.
Okay. And what did you base that description on?
The witness had taken a picture.
Okay. Did you later learn that the suspect was not black?
Immediately after, she was standing in front of me when I had the phone looking at the picture. Immediately after I said that, she corrected me.
Okay. And so what was the ethnicity or race of the suspect?
Hispanic.
At some point, was someone found who matched the description that you put out over the radio?
Yes.
Do you recall which officers found that suspect?
Officer Gabriel Mendoza.
At some point, did they bring them back, the suspect back to you?
Yes.
Do you see the suspect here in the courtroom?
Yes, I do.
Okay. Can you point to him and identify him or both?
He has a white shirt.
And what was the name of the suspect?
Marco Contreras.
If the record would reflect that the witness has identified the defendant. At the end, I guess, did a detective come out and make the scene?
Yes.
At the end of the detective and all the officers' investigation, so the determination made to arrest the defendant.
Yes.
What was he arrested for?
Aggravated robbery.
There are no work passed away.
No questions. Witness may be excused.
All right, thank you. Your excuse, thank you. State, call your next witness.
The state called Officer Gabriel Mendoza.
Would you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, have a seat, and if you just state your name for the record.
My name is Gabriel Mendoza.
State.
Thank you, Judge. And before we begin, at this time, we would offer State's Exhibit 1, which is a DVD of the 911 calls that has been played for defense in the court.
All right. Mr. Robinack, would you like to approach to make your objections?
Yes.
All right. Brenner. Yes. All right, State, any further questions?
Yes, sir.
Okay.
Okay. Officer Mendoza, thanks for being here today. Could you please introduce yourself to the jury? I'm sorry, Judge, was he sworn in?
Yes, he has been sworn in. It's been a long day, I know.
We're about to introduce that.
Okay. How are you currently employed?
The city of San Antonio Police Department.
Okay. Are you a peace officer with them?
Yes, sir.
How long have you been with SAPD?
Since 2006, so 15 years, almost 16.
And where are you currently stationed?
I'm currently stationed at our main headquarters in our Minnesota unit.
Prior to that, where were you stationed?
I was stationed at South Patrol.
Would you have been on South Patrol back in 2019?
Yes.
Do you recall if you were ever dispatched out to a walk-in for a robbery?
Yes.
I guess, what do you recall from that day? What were you dispatched out for?
I was dispatched out for the robbery as cover. Proceeded that way, which was east of the location where I was at parked, yes.
Did you make the scene? Did you go to the walk-in first?
No.
Where did you go?
On the way to the scene or to the general vicinity of the scene is when I came across the defendant here and matching the description that was given out.
Okay, you said the defendant. Is that the defendant here? Do you see the person that you took into custody that day here in the courtroom?
Yes.
Okay, can you point to him and identify an article of clothing?
Gentleman over here in the white.
If the record can reflect that the witness has identified the defendant. Do you remember what direction he was, I guess, what street was he on?
On Southwest or Military Drive, I believe it was Southeast Military Drive.
What was he doing?
He was on a bicycle.
Do you remember the color of the bicycle?
It was red.
And what was he wearing?
He was wearing a black shirt and black pants with white Nike shoes.
Going back a little, do you remember if you were given information about where the suspect was heading, in what direction?
The direction was stated to be south on Preston Street.
Away or towards military?
Away from military.
But you ended up finding him on military?
Yes, sir.
When you saw him on the bike, what did you do?
I got on the radio and I called out saying to the officer that was either directly behind me or in front of me. I don't remember exactly where that officer was at. I was saying, hey, I believe that's the suspect, and we just passed. And I turned around, just passing the road tracks, guardrail area crossing. Turned around there and then approached the individual on the bike.
Okay. Did you have your gun out when you approached him?
When I exited my vehicle, I didn't approach with a weapon, put my key weapon out.
Why is that?
It was stated that he had a knife in his possession. He had committed aggravated robbery.
Okay. When you approached him, what did you tell him?
I just wanted to get off the bike on the ground.
Did he do that?
Yes.
Were you able to take him to, I guess, to detain him?
Yes.
Was he searched?
I did not search him. I held cover while another officer did put him into handcuffs, and he was then picked up and moved over to another patrol car where search.
Okay. Are you aware of whether or not if any weapons or anything were found on him?
I don't recall.
Do you remember if you and other officers searched the area for a weapon?
Yes.
Do you remember about how many officers were out there searching?
86.
And what was the area like? Was it business, residential?
So that area where it was at, there's a wooded area just south of the sidewalk where he was located at. Bunch of trees, bunch of brush. And then just further east of there, it was an open, it looked like he was trying to get closed down business. That it was no longer a building there. It was just kind of blocked off with a piping, like a piping fence. And then further east of that would be more brush, more trees, and the road track.
And so after searching the area, y'all were not able to find the box. Bolt cutters are a knife.
No.
What did you do after you all had Mr. Contreras and detained and in custody?
We relocated back to the walk-in.
At some point, if you were there, was the field ID done? Were you present for that?
I don't recall if I was.
Okay. Your Honor, may I have a question on this?
Yes.
And what, showing you what's been marked as State's Exhibit 2. It's a DVD. Do you recognize this DVD?
Yes.
Okay. Is that your signature on the DVD?
Yes, my initials were that.
Yes. And as an officer with SAPD, are y'all equipped with body-worn camera capable of making an accurate recording of events that they occur?
Yes.
Is State's Exhibit 2 a true and accurate copy, other than the fact that it's been muted, of the events as they occur?
Yes.
Your Honor, at this time, we would offer State's Exhibit 2 as evidence.
With the representation, it's been muted, no objection.
All right, State's Exhibit number 2 is admitted.
May I play for the jury, Judge?
Yes.
Your Honor, at this time, I'll pass the witness.
All right, defense.
No questions.
All right, is this witness subject for recall or excused?
Subject to recall, Judge.
All right, thank you. You may step down. State, call your next witness.
The state calls West Young.
Yes. Yes. Could you raise your right hand for me, please? Raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand and make sure that you speak up so that the jurors will be able to hear you. If you could state your name for the record, please.
Quest, how old are you?
22.
Do you live here in San Antonio?
Yes, sir.
Are you working anywhere?
Yes.
Where do you work?
I work at walk-in. Zamarripa.
Where is it located at?
Big time address.
General.
Military drive over my savings.
How long have you worked there?
2 years. 23.
23?
Yes.
What do you do there?
I'm a cook at that strong workshop. Yes.
Have you been a cook there for the entire 3 years?
No, I had to like work my way up to like cook. I went started small and ended up getting into cook.
What's the name of the manager at that location?
Andrew for me.
Sorry, were you working there in 2019? June of 2019? If you don't remember, you can say I don't remember.
It's very hard. I left for like a whole year because I was in college.
Okay. And so I guess were you working there with an Arnold or an Norfolk Canado?
Yes, I was.
How did Arnold get, what did you call him?
Arnold.
Arnold, okay.
Or Arts.
Art, okay. How did he get to work?
He did come to work sometimes when I'm drunk. Right now.
Sorry, I meant what mode of transportation?
A bike. Oh, sorry.
So he would ride a bike to work?
Yes.
What did the bike look like?
He had multiple bikes. He had 2 bikes. I think he would alternate sometimes. His first bike was black. And that was very chrome and also very nice and red.
Does Arnold still work there?
No, he does not.
Okay. Do you recall an incident where police were dispatched out to the walk-in?
Are you asking the day of?
No. Do you remember it?
Yes, before. Plenty of times. Yes, before.
Oh, okay. What was going on that day? Let me ask this. Do you remember who was working that day?
Yes. Most. I can name it for now. A few.
Was there a day that someone came and tried to steal Arnold's bike?
Yes, there was.
Okay. Was Andrew working that day?
Andrew. Oh yeah, I'm sorry. I'm very. I'd like to ask. Are you asking the incident or like was this a different incident?
I'm asking about the incident where someone tried to steal Arnold's bike.
Okay, Andrew. Yes, Andrew was working.
Okay. When did you become aware that someone was trying to steal Arnold's bike?
I became aware when one of the women in the front came to the back and said that somebody.
Objection, you say.
Sustain.
So someone from the front came back and told you something. Based on what they told you, what did you do?
I reacted off of this Arnold's movement and I had proceeded to the back of the kitchen to go view and see because there's like this big opening, like a window where you can see clear as day as outside. I didn't go directly to the front, but I just went to a site where I can see everything that's happening.
Okay. What did you see outside?
What I saw was the man was cutting out on bike with some wires or Walker's not very sure of what he's cutting out of. One of the brushes to the front of the store goes outside, just as my manager goes outside and sees everything. And I did see him trying to take the bike. Do not know the words that were exchanged between Andrew or Arnold to the man. But I do know that what I see was him trying to take the bike from him.
Okay, and so initially outside it was just Andrew and Arnold?
Yes.
And the man trying to kick the bike?
Yes.
Did you see the man who was trying to kick the bike here in courtroom today?
Yes, I did.
Okay, can you point to him and identify an article of clothing?
Oh, right, but I'm sure it's me right over there.
Okay, and the record, let that record reflect that the witness has identified the defendant. So you saw them arguing that you couldn't hear what was being said, is that right?
No, no, sir.
So what did you do next?
I saw them long enough to where I think I should go out there.
Did you go out there?
Yes, I did. And I went out there, took off my apron, sat it down on the counter.
Who went outside with you?
It was me, another coworker named Jerry. I don't remember anybody else.
Okay. Once you got outside, what happened?
I get outside. Arnold has his chair in his hand. Andrew was trying to still get the bike. I get closer to him to show some kind of effort of helping my boss get the bike. And then after that, he proceeds to reach in the back of his pocket and pull out a knife.
And by he, do you mean the defendant? Yeah.
Yes.
What was, sorry, I forgot to ask, do you remember what he was wearing that day?
No, I do not.
Okay. No. Could you see where the knife came from?
It came from the back of his pocket, I believe.
What did the knife look like?
I can't remember.
Do you remember if it was small blade or a big blade?
As what I was hearing.
No, if you don't remember.
I don't remember.
Okay. And so once he put out the knife, what happened?
I backed away as my boss also told me to back up.
Do you remember how he was holding the knife?
Nowhere higher than his waist. I see it down.
Was it pointing down or pointing towards you all?
It was pointing towards us.
Do you remember if he walked towards you all?
I don't remember exactly because it was like very big steps, maybe to like a few inches, and I can't make sense.
Okay. And about how long did all of this take place? Like, was it minutes? More than 5 minutes? More than 10? If you remember.
I want to say more than 5 minutes because the moment, I guess I was the case. The first, Andrew, my boss, and Arnold had went outside. They were talking pretty big. Yeah, too. And then more time this would show. He didn't like stop from coming out the light. It was just like a saying, "Hey, that's not sure." He kept going. Everything that was being told to him.
So how did the situation end?
One of my coworkers, Jerry, that also went outside. He got very intimidated by him, so he backs away and he just runs off. And he runs off towards the back of the store. He goes around though.
Did you see him after he went off?
I ran to the back of the store and I noticed. Don't know where he got another bite, but supposedly there was another bite, and I see him.
What color was that bike? If you remember.
I don't remember.
Okay.
I'm thinking right, but I don't.
Okay. At some point, were you taken to do a photo lineup by SAP?
Yes, I was.
Okay.
Yes.
Do you remember if you identified someone in that photo lineup?
Yes, I do. They asked me.
Okay. Earning that first list?
Yes.
Showing you State's Exhibit 3, do you recognize this document? This first question, is that your name there? Is that your signature?
Yes.
And is that your signature?
Yes, sir.
And so, looking through it, is that your signature there on the second page?
Yes.
And do you recall being shown these documents by the detective?
Yes, I do.
All right, this time we'll pass the witness.
All right. Defense, your, the motion limited, if you all could approach briefly.
Thank you, Your Honor. Mr. Young, I don't believe we've met before, have we?
No, sir.
Thank you for being here today. It's nice to meet you, young man.
Nice to meet you, sir.
So I just have a couple questions for you. And is it fair to say that in the very beginning that when the person you've identified as Mr. Contreras was out trying to cut the lock, that there were 2 or 3 people that were around him?
From what I was seeing.
Yes, sir. Well, I think you testified that the people that were out there that were dealing with him were Mr. Trevino, right? Your manager, is that correct?
Yes, sir.
All right. And then also Arnulfo Canedo, correct?
Yes, sir.
Do you remember anyone else being out there at the beginning when you were still inside?
I do not remember. I can say the door was still open, so it seemed like somebody was out there because our store door was kind of so. I could say that there's somebody else technically outside of them, but not as outside as close to like Andrew and Farm was.
So I'm not going to pick you to death over whether it was 2, 3 people, 3 people, 4 people. I'm simply asking in general, were there 2 or 3 people more or less at the very beginning around Mr. Contreras who you've identified? Is that fair to say?
Yes.
Okay. And then at that point, you are inside the door. Is that also fair to say, sir?
Yes, I am.
All right. And then at a time later, whether that be 30 seconds or a minute, at some point you decide that you're going to go outside with some other people. Is that right?
Yes.
And I think you'd mentioned a Jerry. Is that correct?
Yes, sir.
Right. And then there was you. Is that right?
Yes.
Were there maybe one or two other people, or do you remember?
I do not remember.
Okay. So at the point you're going outside, there's at least four, maybe more people that are around the person you've identified as Mr. Contreras, correct?
Yes.
And Mr. Contreras is alone, right?
Yes, it is.
So when you're dealing with Mr. Contreras, I just want to make sure I understand. At some point, you say that he pulled out a knife, right?
Yes.
And I want to be clear, you're not saying that when he pulled out the knife, he said, I'm going to cut your throat, or I'm going to hurt you, right? You're not saying that.
No,
In fact, he didn't say anything, correct?
no, he didn't.
And I believe by your testimony that the knife was, pardon your honor, may I stand up to demonstrate that? The knife was close to his waist, right?
Yes.
He wasn't moving the knife forward or swinging it, right?
That was really not.
And you testified maybe he moved his feet or took a small step, is that correct?
Yes.
But you're certainly, your testimony isn't that, and pardon me again, your honor, may I somewhat approach the witness to demonstrate? You're not saying that Mr. Contreras walked forward like this, correct?
Yes. Yes.
All right, so just to be clear, you're not saying he did that, right?
Yes, I'm not saying that.
Okay. I don't know if I heard you right. Are you saying that, and I'm so sorry, everyone else laughed and I missed the joke, which often happens. Are you saying that Mr. Canedo is sometimes drunk at work?
No, I was on.
Okay, I just didn't know if I heard right. So I just wasn't sure. Was he intoxicated on that day?
No, he was not.
So when Jerry moved towards Mr. Contreras, did Mr. Contreras at that point the knife at Jerry?
No, he did not.
All right. And did he tell Jerry to get back?
No.
All right. Did he say, I'm going to cut you if you come near me?
No, he didn't.
In fact, what he did is he ran away.
Yes.
Were you able to tell, well, no, I'll strike that. Pass on this.
Stay.
No further questions, Judge.
All right, is this witness excused or subject for recall?
Judge, on this witness, I would ask that he be subject to recall. I would certainly be able to give him an hour's notice, so I don't need him to sit outside. Does the state have his contact so that if we needed to give him, I don't want the man to have to sit around the courthouse all day tomorrow, but if we did need him, would that be sufficient for the court?
Yes.
Thank you.
All right. They may end up calling you back as a witness. The rule has not been invoked.
As I said, we're rusty. I ask that the rule be invoked.
All right, the rule has been invoked. What that means, you can't discuss your testimony with anyone. You may speak to attorneys for the state and attorneys for the defense only. Do you understand?
Yes, sir.
All right, you can step down. State, call your next witness.
I have a reproach.
Yes.
Possession of older. He had possession of controlled substance and he got deferred. That's what. I don't think that you're care about it one way or another. All right, it's also not admissible. And it just isn't.
All right, we're gonna take up your matter, Mr. Gallardo. And Mr. Gallardo, are you able to unmute for me?
Yes, ma'am. Yes, Your Honor.
All right, the party is ready on Mr. Gallardo. Mr. Martinez?
Yes, Judge.
Your microphone is not working. We can't hear you.
Oh, we're on, we need to change it over.
Is that any better? Hello?
There you go. We should be able to hear him now.
All right.
Can you hear me?
Yes.
Okay.
All right, the court is calling 2022 CR 2871 and 2022 CR 1613, State of Texas versus Gilberto Guayardo. Can I have parties announced for the record, please, for the state,
Joe Ray Garcia.
for the defense?
Luis Martinez on behalf of Gilberto Guajardo.
And are you Mr. Guayardo?
Yes, Your Honor.
All right, we're proceeding by video due to the pandemic. Any objection from the state or the defense?
I'm from the state.
No, Judge.
And each of these cause numbers, Mr. Gallardo, I'm showing you what's entitled defendants consent to appear by video conference. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily consented to appear by video. And each of the cause numbers, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review those documents with your attorney? Did you understand them and did you sign them?
Yes, Your Honor.
Counsel, in each of the cause numbers, I'm showing you what's entitled discovery acknowledgement. Have you received the discovery in each of these cause numbers?
Yes, Judge.
To review it with your client?
Yes, Judge.
All right, to the clerks in the back, I do not have discovery on 2022 CR 2871. Court will find that the state is in compliance with discovery. Mr. Gallardo, in each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney in each of these cause numbers? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment in each of the cause numbers?
Yes, Your Honor, we do.
State, in each of the cause numbers, are you proceeding on the indictments as presented?
Yes, Your Honor.
Mr. Gallardo, in each of the cause numbers, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them? Did you electronically sign them in all the appropriate places?
Yes, Your Honor.
In each of the cause numbers, you charge, I'm sorry, in cause number 2022 CR 2871, you're charged with felony in possession of a firearm. And in cause number 2022 CR 1613, you're charged with possession of a controlled substance, penalty group 1 gram to 4 grams. The range of punishment in each of those cases is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, right, for you or your attorney to cross-examine and confront any witnesses the state would call on the right to remain silent. Did you understand?
Yes, Your Honor.
You understand by entering into a plea bargaining agreement in each of these cause numbers, you are giving up those rights.
Yes, Your Honor.
And you intend to give up those rights and enter into a plea bargaining agreement in each of these cause numbers.
Yes, Your Honor.
In each of the cause numbers, did you understand that the court were to grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty, not grant you community supervision, and sentence you up to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to these offenses?
Yes, Judge, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Judge.
Do you believe he's currently competent, was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gallardo, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, Your Honor.
Has anyone promised you anything other than the plea bargaining agreement to get you to enter the pleas?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
No, Your Honor.
In each of the cause numbers, Mr. Martinez, did you have a chance to discuss with your client the consequences of entering into a plea and how it relates to his immigration status?
Yes, Judge, we've discussed it and we believe that this is the, while there's always risk involved, we believe this is the most benign combination of charges that we can plead to.
Did you discuss with him the possible consequences such as deportation, exclusion from admission to the United States, or the denial of naturalization?
Yes, Judge, we've discussed that.
And do you believe he understands that?
Yes. He's at this point is a lawful permanent citizen, Judge. He understands that these can cause issues with that residency. I'm sorry, lawful permanent residence. And he understands that these charges can cause problems with that. And he is going into this plea bargain knowing the risks.
All right, Mr. Gallardo, did your attorney explain to you that by entering a plea of no contest or guilty, that there are certain consequences as it relates to federal immigration? Did he explain that to you?
Yes, Your Honor.
Did those possible consequences include deportation, exclusion from admission to the United States, or the denial of naturalization?
Yes, Your Honor.
Right. And do you understand the consequences of entering a plea in each of these cause numbers and as it relates to federal immigration?
Yes, Your Honor.
And knowing that, do you still wish to proceed?
Yes, Your Honor.
In each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargaining page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargaining agreement in each of the cause numbers, the cases are ranked current. There's a cap of 5 years in the prison, a $1,500 fine. The state opposes your application for deferred adjudication or community supervision. In each of the cause numbers, they will take in consideration 2022 CR 2870, 2022 CR 1612, and 2022 CR 2249. Did you understand that to be the plea bargaining agreement?
Yes, Your Honor.
Defense is at the plea bargaining agreement.
Yes, Your Honor.
State defense is at the plea bargaining agreement.
Oh, I'm sorry.
It is, that's my understanding, Judge.
State is at the plea bargaining agreement.
It is, Judge.
In each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Then in cause number 2022, defense, have there been any such motions in each of the cause numbers?
Been none, Judge.
Then Mr. Gallardo, in cause number 2022 CR 2871, how do you plead? Guilty, not guilty, or no contest?
No contest.
In cause number 2022 CR 1613, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support those pleas.
State offers State Exhibit 1, its attachment in each of the cause numbers.
Judge, there's no objection to that.
Mr. Gallardo, in each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you electronically sign them at all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
I understand. Yes, Your Honor.
And that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
These are the cause numbers of find that defendant voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, each of the cause numbers as a review and states exhibits 1 and attachments. The court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you apply for deferred adjudication. Ms. Ferguson, if I could have a date for sentencing, please. All right, we're going to come back on June 30th. Is there a need for a copy evaluation, Mr. Martinez?
I don't believe so, Judge.
All right, then I'm going to send you to a breakout room to speak with Ms. Reyes. She will give you instructions and you all will be excused from the breakout room.
Thank you, Judge. And so the court knows there are some off bonds that were filed and some cases we held without bond. So I will have motions to set bond forthcoming.
All right, thank you. All right,
Thank you,
you
Judge.
all go to breakout room number 2, please. And guys, this will be the last witness for today, or do you all have more?
We have 1 judge. I think if I was gonna ask if the court is okay, if we stay probably even till 5, we would finish
Sure.
our case in chief.
Oh, yes, let's, all right, thank you.
Judge, we're getting some of the discs together so we can hopefully finish the little errands that we needed to do for states exhibit 1 and some of the other ones.
Okay, can you mute us?
Hello?
And we can bring the jurors back in.
Judge, that was admitted or no?
Oh, no, they haven't admitted it yet. They're gonna offer it though.
You're a court reporter in training, young woman?
Yeah, she's a student.
Yes.
All right, so the jury.
Brenda, remind me because somebody texted me.
Okay.
They want some information about court reporting.
Oh.
Oh, no, please be seated. I know the chairs are very hard. We're working on buying pillows because we have to buy pillows for each seat. So when there's a sale, I will go out and buy pillows.
Judge, 2 words for you, TJ Maxx.
Okay. All right, everyone, please be seated. Ladies and gentlemen, I know, and we're off the record for a moment, Brenda. I know that I said that I would let you all leave at 4:30, but I'm being told that the state will be able to finish up their case if we go a little bit later. Is everyone okay with that? All right. Thank you. All right, state, if you'll call your next witness, please.
Yes, Judge. State calls Officer Mendoza.
All right, Officer Mendoza, you're still under oath. All right, state.
Can I make special witness?
Yes.
Officer Mendoza, I'm showing what's been marked as State's Exhibit 14. Do you recognize that?
Yes.
What is that?
It is a red bicycle there.
Okay. And is it a fair and accurate depiction of the bicycle on a?
Yes.
Fair and accurate summary offer State's Exhibit 14?
Any objections to State's Exhibit number 14?
No objection.
All right, State's Exhibit number 14 is admitted.
Just to be clear, State's Exhibits 1, 8, and 2 have already been admitted. Correct?
Now, but are you offering 1A?
Yes, the state will offer State's Exhibit 1A.
And defense, the court notes your previous objections.
That's all right. Thank you.
And states, and those they will be overruled, and State's Exhibit 1A is admitted.
And so, Officer Mendoza, you said this is the bicycle that the defendant was riding when you spotted him?
Yes.
And then earlier we talked about wearing body cam, and I want to play that for the jury. And is there normally audio in your body cam? Does it normally capture audio?
Yes.
Okay. But you reviewed this and the entire video has been muted, correct?
Correct.
At times, I guess, when you're out at the scene, do you speak to officers and witnesses and sometimes random individuals?
At this particular scene, all right, scenes in general.
Scenes in general.
Yes.
Okay. Do you sometimes have conversations that don't pertain to the case?
Yes.
And just to be clear to the jury, you didn't mute the video, we were the ones who did that, correct? Correct. What is the jury looking at here?
It's me responding to the call as covered. And I'm traveling, I believe it's gonna be eastbound on, at this point, Southwest Military Drive.
Or as you're driving down, I guess, or reporting to a scene, are you receiving information from dispatch?
Yes, from dispatch, from either officers already on scene, and then also maybe even what the 911 caller might have called in, whatever information it is being read out over the radio or on our NBC laptop, for that conditions.
So I'm fast forwarding to timestamp 1947:27. What's going on here?
So at this point, when you went to 1947:27, was where I was doing the U-turn. I had already noticed the defendant on this bike traveling westbound on Southeast Military Drive along the sidewalk. And at that point, when I got the radio, I got real quick, hey, to this officer, hey, Scott, this is the suspect, let's turn around. So as I'm turning around, giving him that information, and then I drive up past him to obviously cut him off there, see that there was a wood line that he could easily run into if he wanted to.
And earlier you described the area and you said that there were a lot of trees and brush. Is that what the jury's seeing in this video?
Yes.
What are you doing at this point?
So at this point, I've already walked away from the patrol cars and I'm looking in the vicinity where he was possibly traveling from. Because again, where I finally saw him was somewhere just west of this location. And that's when I picked him up and then I turned around and he was already still continuing westbound. So at this point is where I'm looking for the weapon, knife. And was to have had for the robbery.
And is this one of the other officers who was searching the area?
Yes, sir.
Why were you searching this area?
Again, we're just seeing if maybe something was thrown against in the general area where he could have possibly come from. That's what I wanted to see.
In a play, you said that you also received information from dispatch regarding the 911 calls, correct?
I'm sure I did.
And this complaint states exhibit 1A, which has been.
San Antonio 911, this is Veronica, do you need police, fire, or EMS?
Police.
Okay, what address?
I'm sorry, we're on, what's the address? What's the address? It's right here on top. I'm sorry, we're getting them on the other line. I'm sorry, they have people calling the 911.
Okay, do you still need me?
Thank you.
Huh?
No, thank you.
Okay, bye-bye. I cannot believe it. Yes, there's somebody in front of my store at the walk-in, and he's stealing our friend's bike.
What's the address?
The address is, he's trying to fight him now. Oh my God, the address is, shit, where's the address? I don't know, I'm looking and I don't see it. 2230 Southeast Military.
So he's fighting your friend now?
Yeah, my manager's outside. Well, he's leaving now, but he's trying to steal my friend's bike. He has bike cutters and he's trying to assault our management and staff.
Did he hit anybody who was trying to?
No, he didn't. He was trying to. He's walking towards the Valero. We're in a shopping center, 2230 Southeast Military.
Is he black, white,
Okay.
Hispanic?
He's Hispanic. He has on all black, a black shirt, black pants, black shoes. He looks like he's high.
Her name?
My name is Quintina Jones. I'm an employee here, a cashier.
The telephone number to there, is it a 596-9188?
That's correct.
Okay, I'll get somebody else in. Thank you.
Thank you, bye.
Your Honor, at this time, we'll approve the witness.
All right. Defense.
Any questions?
All right, is this witness excused?
Yes, Judge.
Yes, Your Honor.
All right, thank you. Call your next witness.
The state calls Andrew Trevino.
you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, if you can lower your hand, make sure you speak clearly and loudly so that the jurors can hear.
Yes, sir.
Could you state your name for the record, please?
Andrew Justin Revenue.
State.
Thank you, Judge. Andrew, thanks for being here. How old are you, Andrew?
35.
How are you currently employed?
How am I currently employed?
Yes, sir.
You mean to like my occupation?
Yes, where do you work?
I work at the Walk-In Asian Cafe. I'm the general manager.
How long have you worked there?
I've been with the company almost 15 years.
How long, actually, what location are you a manager of?
Right now, I'm currently at the Southeast Military Location. So we refer to it as number 7, and we opened that one back up January of 2019.
And the jury heard testimony from West Young. Is he an employee there?
Yes.
And the name Arnold Arnolfo came up earlier also. Do you know him?
Yes, sir.
Do you know his full name?
I believe, I might butcher the pronunciation, but Arnoldo Caneda, I believe is his name.
Canedo?
Yes, sir.
Okay. And did he go by Arnolfo?
Arnolfo on his legal paperwork, but his nickname was Arnold, so we all just called him Arnold.
Okay. How did Arnold get to work?
He
Transportation wise.
rode a bike.
And have you always been at that, can't remember fast, have you always been at that military?
I've worked, I mean, we have a total of 8 restaurants now. I've been a part of at least 5 of them in smaller capacities. I've previously managed our number 3 location for about 9 years and then transitioned over to this one full time.
Okay. In June of 2019, were you at that location?
Yes, sir.
Do you remember an incident where someone tried to steal Arnold's bike?
Yes, sir.
What's your first, how did you first become aware of someone trying to steal Arnold's bike?
One of the front house employees, this younger girl, Danielle, she actually lives in the same, at the time, lived in the same complex as Arnold, so knew he rode the bike, his bike is in front, and just comes to the back and says, Arnold.
Objection, here, sir.
Sustained.
So Danielle came to the back and said something to you?
Correct.
Your Honor, may I approach the witness?
Yes.
I'll show you what's been marked as State's Exhibits 4 through 13. Can you look at those and tell me if you recognize them?
Yes, sir.
Okay. Okay, and so State's Exhibits 4 through 13, are they fair and accurate copies, true and accurate depictions of what they pretend to show?
Yes, sir.
And these are pictures taken from June 11th of 2019.
Yes, sir.
Have they been altered in any way as far as you can tell?
No, sir.
We'll offer State's Exhibits 4 through 13.
Judge, I previously reviewed them. I have no objection.
All right, State's Exhibit 4 through 13 are admitted without objection.
So Andrew, is this the sign outside of the 2230 military location?
Yes, sir.
And that's State's Exhibit 4. State's Exhibit 5. What does the jury look at?
That's the front face of the building.
And then State's Exhibit 6.
That would be the 3 bike racks that are currently in place there.
And this individual in the red, can you tell who that is?
That's Quest.
And State's Exhibit 7, is that the same?
Same rack, different angle.
Where was Arnold's bike on this day? Was it on that rack?
It was, I don't remember precisely which of the 3 that he had it chained to.
Okay. And so Danielle comes inside and she says something to you. And then what do you do as a response to what she said?
I run to the front to get a visual for myself.
Okay. What did you see?
There was a gentleman out there that was attempting to cut the chain off of his bike.
Off of Arnold's bike?
Yes, sir, sorry, off of Arnold's bike.
And State's Exhibit 8. Is that a picture of Arnold's bike?
Yes, sir.
And the chain that you just mentioned, State's Exhibit 11, is that also Arnold's bike?
Yes, sir.
The chain that you mentioned, is that what we see in State's Exhibit 10?
Yes, sir, you did.
And so you said there was someone outside trying to cut the chain off the Arnold's bike.
Correct.
What did you do in response?
Originally, I approached the individual and just sort of trying to make conversation, question the action. And then at that point, it was sort of, I guess, trying to figure out how to approach it further. Like, what exactly are we going to do to stop this at that moment?
At the moment that you walked outside, did you go by yourself or with someone?
When I got to the front and realized what was really going on, I turned around and called for Arnold because it was his bike. And I walked out front and I can't remember if Arnold was, he was behind me. I just don't know how far exactly behind me, if he was right behind me or a few feet, but I mean, I went out first and just kind of approached a little bit.
Okay. And so you approached the individual?
Yes, sir.
What was the individual wearing?
I believe it was a black shirt and blue jeans at the time.
Okay. What ethnicity or race was he?
I assume Mexican.
Do you see that individual in the courtroom today?
Yes, I do.
Can you point to him and identify an article of clothing?
White shirt.
Okay. And so when you saw the defendant trying to cut the chain, what did you do?
Originally, when I walked up, my first thought was just conversation, like kind of to, in my experience, it's been easier to verbalize what someone's doing in order for them to see it for what it is, that action. So the first thing I said was, "Are you really trying to steal a bike in the middle of the day in front of the store in broad daylight?"
And did he respond?
Yes, sir.
What did he say?
The only thing I can really remember was real short was, yeah.
Okay. And what was he trying to steal the bike with?
It looked like a very small pair of bolt cutters. Like when I saw them, I felt like, I mean, if I had to compare it, it's like the difference from buying a tool at maybe Harbor Freight versus going to, Lowe's or specialty store. It just looked like a very small, cheap pair of bolt cutters.
Okay. And so he's using the bolt cutters to try to cut the chain.
Yes, sir.
And he tells you that he's trying to steal a bike.
I mean, those weren't his words. His words when I asked him, really trying to steal it was, yeah.
Okay. At some point, did you try to stop him from stealing the bike?
There was a point when he was able to actually, when he finally was able to break the chain free, because Arnold had coiled it around the bike, as you do. As he ripped it off, it caused him to kind of take a step back off the curb. And when I saw that there was a little bit of distance and the bike wasn't locked, I just lunged in and kind of grabbed it and stepped back with it.
Okay. And was the walk-in, did that location have surveillance video?
It does, yes, sir.
Have you had a chance to review, Your Honor, may I approach the witness?
Yes.
State's Exhibit 15, which is a copy of the surveillance video. Did you have a chance to review it?
Yes, sir.
And when you reviewed it, was it a true and accurate depiction of the events that occurred?
Yes, sir.
And I'll submit to you and defense in the court that it's been muted. But other than it being muted, is it true and accurate copy?
Correct. Everything you see is what you see.
All right, we'll offer State's Exhibit 15 as evidence.
Any objections?
Gentlemen, thank you. Just give me a second. May I take the witness on board?
Yes.
And, Mr. Trevino, are you the person that reviews the videotapes for that location?
At the time I wasn't, now I am.
So at the time you weren't the person that keeps the videotapes, that stores them, that makes sure they're accurate, correct?
Correct.
I guess my question to you is, this isn't your viewpoint of what's happening, right?
It's the camera's viewpoint, sir.
Okay. All right, pass the witness, no objection.
All right, and that was state's exhibit number 15.
Yes, Judge.
State's exhibit number 15 is admitted into evidence.
And may I play it for the jury?
Yes.
Actually, sorry. Can you testify that at some point he was able to cut the chain? Is that what's in State's Exhibits 9 and 10, the cut chain?
Yes, sir.
In State's Exhibits 12, what do we see here?
That's the gentleman hasn't quite cut it yet, but was working on it, and I'm actually the one on the left standing there closest to him. Yes, sir.
And then in this hand, what is this?
Those are the bolt cutters.
Okay. And then what's he doing with his other hand?
In that picture, I think in that picture, he's actually kind of, I don't know if he's trying to straighten it out or pick up the pants or something in that photo.
Okay.
Can't really attest to that exact moment in time.
Okay. And State's Exhibit 13, is this him still trying to cut the chain?
Yes, sir.
And play State's Exhibit 15. And so, is this the surveillance video from inside the store?
Yes, sir.
Who's this individual right here in black?
That is Miss Danielle.
Okay. Does she still work at that location?
No, sir.
Who is that?
That's me.
Is that when you were alerted that he was trying to steal the bike?
Yeah, correct.
Who was that ran out in blue?
In the blue, that's Arnold.
And so here we're seeing you step towards him. Is this, what are you doing at this point?
I think at this point, we were kind of observing. Like I said, it's not exactly a playbook we've read on how to address that sort of action at the time. So we're just kind of watching, okay, what are we gonna do next? What is our play?
And was that Arnold trying to reach for the bike at that point?
Correct.
Why did y'all take a step back here?
When Arnold took that step forward, I think it might have taken a moment, but I can't remember precisely, like 100%. It's been 3 years, but he either gestured for, or he actually, I believe he pulled out a knife at that point. So we had nothing, so we took that step back at that moment.
What did Arnold just grab?
I had instructed Arnold to grab a chair off the patio, so we at least have something in our hands.
And so if you remember, did Arnold grab the chair before or after he pulled out the knife?
After.
Okay, so he had already pulled out the knife.
He pulled it out, pulled it out, saw it, and then once we kind of took that step back, the knife went back away. I was like, grab a chair or something.
Okay. What did the knife look like?
It was probably a good, at the time, I would say about 5.5, 6 inches of, just straight what you would use, I don't know if anyone's ever seen the movie Scream. That was kind of how I remember the knife in my head. Not as long, but around that kind of hunting style shape.
Okay, so was it closer to a like machete or butcher knife than a
Jackson leading.
Sustained.
What would you describe it as? Close
I would describe it as kind of straight steel. Not a lot. Only curve that I recall seeing, other than the blade is straight. There's a slight curve, but usually at that tip is where it kind of brings that point together. But if I'm looking at the the blunt of the knife is gonna be a straight knife.
And how long did you say the knife was?
I would say about 5.5, 6 inches. It's a pretty piece of steel.
Okay. And so Arnold grabs the chair. What is the defendant doing at this moment?
Well, when Arnold had walked up with it, I can't remember if he pulled it out or if he kept cutting. I think he might have just, he was fiddling, because like I said, the bolt cutters weren't the best ones. And Arnold has a decent enough chain, so it took him a little while of trying to cut through it with the little bolt cutters. So a lot of it is us just sort of observing, but the adrenaline is starting to kind of kick up a little bit more.
At the time that he pulled out the knife, were you and Arnold trying to prevent him from stealing the bike?
I want to say it came out twice. That first time, no, it was at that point, it was a kind of an approach. We hadn't done anything to make it was just an approach, a step closer, and then, oh, there it is, and a couple steps back and set.
But what was your purpose in being outside?
Originally, when I started talking to him, I figured like, all right, maybe I can just talk him out of what he's doing, because it just didn't make sense to me. And then as it became clear it was gonna happen, I just didn't want Arnold to lose his bike. I mean, at that time, we were really relying on him. It was his own mode at the time. I just didn't want that to kind of happen to him.
Okay, so you were trying to stop him from stealing the bike?
Yes, sir.
Who is this in red and black that we see walking out?
In the red is Quest, and in the black, I believe that was Joshua Camargo.
And at this point, are you all approaching him again?
Correct.
And then what happened just right there?
Wait, as Quest was approaching, I remember him saying, you know, you're not about trying to just take one man's bike like that. And he gets the chain finally busted, and as he ripped the chain off the bike to uncoil it, like I said, it caused him to go a step, maybe a step or two off the curb, to get it all the way off. And when he had pulled it, yanked it, I saw his hands were kind of way up here, so I jumped in, I grabbed the bike, and you see me kind of walking back with the bike at that point. And so once I grabbed the bike, kind of just pulled that knife back out and just sort of held it out.
Okay, and when he pulled the knife out, where was he holding it?
Right hand, I would say closer to like maybe waist high, like stomach height, you know, but keeping it pointed towards the sky at that point.
And then is that him that we see now?
Yes, sir.
Was he coming towards you?
Yes, sir.
Did he still have the knife in his hand?
Yeah, yes, sir. The reason why I'm backing up with the bike is because he had the knife. And I mean, as I'm backing up, I'm kind of just saying, you know, like, I'll hit you with it, you know, I'll swing it at you. Or I hit you. I think I said I'll hit you with it maybe twice as he was progressing.
So then what does he do?
Well, I mean, by that point, he kind of looks like from what I paid attention to, it looked like he was a little defeated. There's a gentleman that's in the black to the right of Quest outside. I believe that's an old employee named Jerry. And I think Jerry's presence was a little, at the time I thought it was intimidating because he didn't seem like he cared about anything. He just was out there to see what was going on. And so when I saw that the attention went from me with the bike to Jerry, because he's talking, at that point, I gave the bike to Arnold, I'm like, put the bike in the store, please, like, we take this out of the equation, we don't have a problem anymore. And so Arnold puts the bike in, at that point, we had switched, so I took the chair from him, gave him the bike, I'm out there watching, kind of gave up, leaves towards the left, so I took the chair with me, and when he started running is when I started running after him with the chair, and got my phone to kind of call it in.
Okay, did you call 911 as you went after him?
Yes, sir.
And as you went after him, I guess, where did you see him go?
We went all the way down to the opposite end of the building, hooked around the side to the back, and then back up towards roughly the middle of the plaza itself. We have a set of dumpsters. He had a red bicycle leaning up there and just hopped on the bike and just took off.
And you said that you called 911 after you went up there?
As I was in pursuit, I was on the phone with dispatch already.
I'm gonna place this exhibit 1A for the jury.
I need police right now.
What address?
Fucking 2230 Southeast Military Drive. Guy tried to steal a bike. He took a knife out on us. He's running right now.
What is your name, sir?
My name is Andrew.
Are you
And
taking it?
he just hopped on another bike. He's on a red bike, headed towards Pressa. The black male, black hair, sideburns running around into a goatee. He's taking off on a bike right now, and he's headed down South Pressa away from military.
On a bicycle, correct?
Yeah, skinny male, probably about 5'10". Hair kind of combed backwards, but he does have a rather large knife.
What is it, the product number, please?
210-279-5425.
I'm sorry, what was your name? I think you
My name is Andrew.
okay, so he was,
We have an employee who has a bike chained out front. We saw someone come up trying to snap the chain. He has a pair of bolt cutters on him. We approached him. He pulled the knife out, tried to swing it. We picked up the chair. He saw me walking around following him, so they called the cops. We called the cops. He booked
so
it flying the rest.
bicycle that he took, is that your friend's bicycle?
It's an employee bike. We have the bike, but he hopped on a red bike that he had parked in the back, and he took off down Pressa.
So he was trying to steal another bike, a different bicycle.
Correct. He was trying to steal another bike.
All right, I'll put somebody else.
Thank you.
And in the 911 call, we heard you say he was a black male.
Yes, sir.
Was he a black male?
No, sir.
Do you have any idea why you said a black male?
I was looking at the pants and I was looking at the shirt. So I was trying to convey black shirt, black pants, but it came out because I was trying to describe it's a male wearing a black shirt. So I ended up saying black male. Like I say, mentally, the adrenaline's going and I'm chasing after him at that point. So I'm not thinking so much as what I'm saying versus what I was doing and where this guy was going.
The person that was on State's exhibits 12 and 13, the individual that was cutting the bike, that's who, I guess, pulled the knife on you that day?
Yes, sir.
Showing State's exhibit 2. Is that the same individual?
Yes, sir.
Your Honor, we'll pass the witness.
Defense?
Judge, I'm gonna ask questions. I just want to know it may be 20 minutes, so I don't know what the court wants to do.
Right, we'll proceed with your questions.
Thanks, Judge. Mr. Trevino, I'd like to turn your attention to when you said you backed up the first time and you said you weren't 100% sure, but you thought you might have pulled out a knife, correct? Would you remember talking to a detective after this incident occurred?
Yes, sir.
Do you remember the detective's name?
No, sir.
De La Rosa sound okay?
Sounds great.
All right. It would have been shortly thereafter.
Correct.
All right. Do you remember telling Detective De La Rosa that the person who reached behind his back and you were unsure if they had a weapon? Remember saying that to him?
It sounds feasible.
Your Honor, may I approach the witness?
Yes.
Mr. Trevino, I'm just pointing you towards part of the report that I read. Do you see where I'm saying that, sir?
Yes, sir.
Okay. And earlier you said you weren't 100% sure. Having seen that statement, are you changing the testimony? Was the detective wrong? Has it just been a while?
It's been 3 years and I have a lot of other stuff going on. So I mean, the matter of every detail in its order of that day, because it's gonna be a little bit fuzzy for me right now.
Sir, I totally get it. We've been through a pandemic and I'm not blaming you. I'm just trying to make sure your statement to De La Rosa at the time, you wouldn't have been through a pandemic. A lot of things.
I mean, whatever my statement was, I stand by that, because that seems to be my freshest account.
All right. And so just to be clear, you agree with me that it's more likely than not, in fact, you hadn't seen the knife when y'all backed up the first time, right?
It was either we saw the knife or it was the gesture of reaching behind one's back to remove something. And at that point, you're not gonna guess, like, is it something good or something bad? You assume it's a bad gesture.
Well, your statement is that you were unsure if the defendant had a weapon on this person.
Correct.
So certainly if he pulled out a weapon at that point, you would have been sure he had a weapon on this person.
You can be a little bit more positive as to what it is. Because I mean, he's holding a pair of bolt cutters, so someone see those as a weapon on its own.
Children, I'm gonna object to non-responsive.
Sustained.
So, and I'm sorry, sir, I know you're trying to be honest with
No,
me.
go ahead.
but my point simply is, you stated that you were unsure at that point if he had a weapon. And then I asked you, so if you must not have seen the weapon or you would have been sure.
At that time, I would, if I said I was unsure that he had the weapon, then the gesture itself is what I was relying on that statement.
Okay. Now, you also stated later on that you believe that the defendant walked towards you with a knife, right?
Yes, sir.
Again, do you remember talking to Detective De La Rosa afterwards, even if you don't remember his name?
I remember speaking to somebody, yes, sir.
Do you remember that you said to them that you moved away from the defendant and the defendant put the knife away and began walking towards you?
Your Honor, I'm gonna object to improper impeachment.
All right, that'll be overruled.
I don't remember that particular set. Him putting the knife. If he put the knife away at any point, it was not after.
So my question just was, do you remember making that statement to the detective?
Not particular. I don't remember everything I said verbatim, sir.
Judge, again, may I proceed?
Yes.
And Your Honor, I guess I would object to him crossing them off the report. There is video where the defendant, or sorry, the witness can view his actual statement and not the detective's summary of the statement. And I believe that would be a better thing to impeach him or cross him off.
All right, that'll be, if that
Objection.
objection will be overruled. You can approach the witness.
Thank you. And again, I'm just reading from it. It says, victim stated, victim is you, stated that they moved away from defendant. Defendant put the knife away and began walking towards the victim. You see that statement there?
Yes, sir.
Okay. And again, I understand things happen. I've been, it's been a long time, but your earlier testimony is that your recollection at the time would have been better, right?
Yes, sir.
All right. And so I'm assuming that it doesn't change with regards to certain things. I mean, your recollection at the time was better. And you stated at the time that, and I'm going to say it was Mr. Contreras, put away the knife and then walked towards you, right?
Well, there's context that needs to be applied in order for that statement to be applicable.
Sure. But I'm just asking you about that statement and did you state it to Detective De La Rosa at the time?
Yes, sir. That statement would have a new definition towards it.
So I guess I'd like to turn to some other things that were said. I didn't hear you say that Mr. Contreras swung the knife at anyone.
Correct.
And I'm just being clear. You're not saying Mr. Contreras did swing the knife at anyone. I'm not saying that. Okay. And by the way, I get that he was taking the bike. I'm not challenging that. I'm just talking about that. I didn't hear you say that while he had the knife, Mr. Contreras said, "I'm going to kill you or I'm going to cut you."
No.
Okay. And in fact, besides the stealing of the bike itself and his response, whatever that was, he didn't actually speak any other words to you. Is that correct?
Correct.
So at the beginning of the video that you were shown, it was you and Mr. Art or Onofo Canado that were out around Mr. Contreras?
Yes, sir.
All right. And at that point, at least according to your testimony or the statement you gave De La Rosa, the knife hadn't appeared at that point, right?
Well, if I'm gonna be honest with you, the statement that you just had me read, that was in terms of he put the knife away and walked away, that was the first time that knife would have come out. And his walking away or walking towards me was that initial, when we backed up, the knife went away. That's why I'm like trying to remember exactly the order of things, because I feel confident that I honestly don't remember that if he gestured or we saw the knife originally, but I remember there was something that caused us to both, when that gesture or that knife, when we saw it, was when we backed up initially, because I didn't know what was gonna happen. But when I got that bike, the knife was out headed towards me.
I'm going to object to that statement as non-responsive and has to be stricken.
All right, that'll be overruled.
So at the beginning portion of it, when there were two people,
Correct.
are you claiming there was a knife out at that point?
I'm saying that I don't recall, when I approached him, there was no knife. I'm trying to remember if it was the action of us moving closer that he gestured and we spooked, or if he had pulled it out. Like my memory feels like we pulled it out twice. First to show we kind of had it, and that's what caused us to back off. And then once I had the bite, it was when it kind of came out and it got a little more real.
Is it fair to say you aren't for sure here?
I mean, it's fair to say that initial, let's say you first 10 seconds of our interaction are a little hazy. Everything else was fairly coherent.
Later on, when there were more people, that's when you, including, in fact, Quest Young, right? That's when you say that the knife came out for sure.
The moment that I actually got the bike and took it back was when it came out. That was at least one of the moments. Like I say, it may have a beginning, but if we're gonna sort of obfuscate this first 10 seconds of our interaction, at that moment that I took the bike away, that knife came out and kind of sort of come in my direction.
My question is, when were there other people around? And I'm talking about.
At that point, he I mean, honestly, he seemed really cool. He's very, very calm. So even with that many people around, while dealing with it, at that point, it hadn't quite been brought out yet. But it took a while.
So with that, again, I'm just trying to focus, and I know you're trying to give information, but I'm trying to focus on when Mr. Young is around you. Okay, is that when you're saying he had the knife out and he was coming towards you?
Well, when he
it's a yes or no. It's a yes or no.
Can you repeat one more time for me? I'm sorry.
When Mr. Young and some other people, in other words, when there were at least 4 people, Mr. Young, Jerry, you, Mr. Canofo, well, at least 4 people. Is that when you said the knife came out and he came towards you?
Yes, sir.
Okay. Earlier in this courtroom, Mr. Young testified, and he had a different testimony.
Okay.
So he was quite clear that he didn't take a step towards any of y'all.
I mean, I don't know what his perspective was, but I mean.
Clearly, both of y'all were focused on the incident, right? I mean, there wasn't anything else holding your attention?
Well, for me, no.
And assuming my statement is true, y'all clearly saw a very different thing. You've testified he had the knife out and was coming for you. And Mr. Young is saying an opposite thing, which is he had the knife out, but he didn't move towards us.
Maybe with him, if you recall the video, him and I aren't even near each other. Wes and I aren't standing each other. He's at least on the other side of our main entrance. So I'm being advanced at moving this way.
But certainly an opposite statement of what you said.
Yeah, I don't know his vantage point.
Judge, may I have about 10 seconds to ask my client something?
Yes. And State, this is your last witness?
Yes, Judge.
All right, ladies and gentlemen, jury, do you mind staying to continue with this last witness? Or does anyone need to leave now? All right. All right.
Pass, please.
State?
Briefly. Andrew, how many times did at the time that you had Andrew grab a chair, had the knife already come up?
I can't definitively say if it had or had. I feel like it did. In terms of why we grabbed the chair, but I honestly can't remember if it was just the act and gesture of reaching behind the back to pull something out is what hit us, or if we actually, if I saw it, we put it back away.
And Your Honor, I hate to do this, and it won't take more than a minute, but I'd like to show him the statement so that he can refresh his
Yes.
memory.
Yes, you can approach.
Okay.
Yes.
And it's not an exhibit that's been admitted, it's a audio statement.
Okay. All right, ladies and gentlemen of the jury. This will take how long? Do you? Okay. We can do this one or two ways. We can come back tomorrow morning. Now, what I will tell you is closing argument, if testimony is concluded by both sides, is going to take place tomorrow morning at a specific time. I promise you, because I moved my entire docket to the afternoon. So this will be in the morning. And we'll start in the morning at 10:30 or 11, 10:30 or 11.
10:30.
10:30. We'll start 10:30.
Yes, sir.
Yes. We'll start with closing arguments tomorrow at 10:30 a.m. Now, if you all are okay to stay for a little bit more, the state and the defense will finish with this witness. And my understanding, this is the last witness from the state. So is everyone okay to stay just for a little bit more to finish up with this witness? All right. So while he gets that together, I'm going to give you guys a slight break because I know sometimes there are a couple of you that may need a restroom break. So we'll do a restroom break and then we'll come back and finish up this with this witness. Remember, you've heard some testimony, but you're not allowed to discuss it with each other or anyone else. Everyone rise for the jury.
And then State's Exhibit 15. This is the defendant coming towards you or away from you, as we're seeing him.
Towards.
So pass the witness, Judge. And sorry, one more question. And did he have the knife out at that time?
It's hard to tell, but I think in that point when he is progressing, when he stops, I believe as he's progressing, it's not in his hand at that moment. Is when he stops moving, is when he brings it back out.
Pass the witness, Judge.
You've had a chance, Mr. Convener, to refresh your recollection now by listening to your statement.
Yes, sir.
Right.
Yes,
Okay.
sir.
And after that, it seems like we're on the same page. So I want to make sure, and then I'm going to let you go. The first time that we were talking about that he reached behind your back, you agree with me that no knife came out at that time. Then there was a second time that the knife was pulled out, correct?
Yes, sir.
But then you agree with me after reflection, you're.
Probably refer to that as the first then.
Okay.
Yes, sir.
First time the knife came out, the
Yes, sir.
second incident we're talking about. But you agree with me that after refreshing recollection, that he put up the knife before he came towards you, correct?
Yes, sir.
All right. And then the second time, or the third incident, but the second time, he did pull the knife out again, but he didn't move forward at that point, correct?
At that point, I don't believe, or I advance.
All right. Which makes it consistent with Mr. Young said, right?
Objection, hearsay. He went.
Hearsay is an out-of-court statement made for the truth of the matter asserted. This was an in-court statement.
Judge, it would be speculation. He doesn't know what Mr. Young said.
And the rule has been invoked. That'll be sustained.
It's argument, it's fine. Pass the witness.
No further questions, Judge.
All right, is this witness excused or subject to recall?
Excused.
All right, the rule has been invoked. What that means, excuse me, sir. The rule, thank you for that. The rule has been invoked. What that means, you can't discuss your testimony with anyone. That means the only persons you can speak to are attorneys for the state and the defense. Do you understand? All right, you're excused. Thank you. Thank you too. State party, the next witness.
Judge, the state rests.
Defense,
We rest.
state,
State closed.
defense.
We close.
All right, ladies and gentlemen, of the jury, you heard all of the testimony and evidence that you're going to hear in this case. But still, you are not allowed to talk to each other or discuss with each other or anyone else anything that you've heard. Does everyone understand? You are not allowed to deliberate at all. Does everyone understand? I don't expect this to be in the media. I don't expect it to be in the newspaper. But if someone starts talking about this, or you see it on television or any type of media or wherever, you need to ignore it and not pay any attention to it. Does everyone understand? So what I've done is I moved my docket to 2 p.m. That way you all will go first. And so I'm going to have you all back here at 10:30 a.m. tomorrow. What's going to happen at 10:30 a.m. tomorrow is I'm going to read you the jury charge. Then both the state and the defense will have a chance to make their closing arguments to you, okay? All right, everyone, please rise for the jurors.